Good morning, everyone. We're pleased to have Judge Norton here today. My name is Rachel Corcoran, and I'm an LLM in bankruptcy student here at St. John's University. As part of our course, Development of Modern Bankruptcy, The Innovators, my peers and I developed a set of interview questions for Judge Norton. But before we get to those, we'd like to give a little background on Judge Norton's impressive legal career. Judge Norton received both his AB in 1948 and his JD in 1950 from Emory University. After studying tax law at Georgetown University and George Washington University Law School, he went on to clerk in the District Court for the Northern District of Georgia. From there, he worked as a Special Assistant Attorney General in the Appellate Section of the Tax Division in Washington, D.C. At that time, he argued 36 cases in 7 of the 11 federal courts of appeals. This was followed up by a stint at the Georgia Department of Revenue, and then you practiced in your own private practice as a tax and business lawyer. Over the course of that time, you had 35 cases in the Georgia Supreme Court and 6 cases in the Georgia Court of Appeals. Then came the real turning point in Judge Norton's career. In 1971, he was appointed to the bench for the Bankruptcy Court of the Northern District of Georgia, where he sat until 1985. Over the course of his tenure on the bench, Judge Norton rendered numerous important decisions, including the Pinegate decision, which will be a topic of discussion later today. You also served at this time as chairman of the Rules Committee for the National Conference of Bankruptcy Judges. You served on the faculty of the Federal Judicial Center, and you became an adjunct professor of law at Emory University School of Law. It was also at this time that you emerged as an educator in the field of bankruptcy. In 1982, you created the Norton Institutes on Bankruptcy Law that featured legends such as Professor Vern Countryman and continue to serve and educate bankruptcy professionals nationwide. In addition to authoring and editing a number of books, Judge Norton is editor-in-chief of Norton Bankruptcy Law and Practice, Annual Survey of Bankruptcy Law, and Norton Bankruptcy Law Advisor. You are recognized as one of the organizing members of the American Bankruptcy Institute, founded in 1982 with the dual goal of providing Congress and the public with an unbiased analysis of bankruptcy issues and educating and serving bankruptcy practitioners nationwide. Your roles on the board of directors, the executive committee, and tenure as president from 1989 to 1991 helped the ABI grow into the organization it is today, over 12,000 members strong. In addition to your efforts with the ABI, you are also one of the founding members and current and longtime fellow of the American College of Bankruptcy, where you served as a member of the executive committee and board of directors, in addition to serving as vice president. You are recognized as a preeminent scholar in the field of bankruptcy, being awarded the first Emory Bankruptcy Developments Journal Distinguished Service Award, and you are known as an idea man and a visionary, ensuring that generations of bankruptcy practitioners to come will have the best educational resources available. Again, we would like to thank you, Judge Norton, for being here with us today.
Yeah, there's so much flattery going on around here that I'm completely intimidated.
After finishing up a stint at the Georgia Department of Revenue, you had a successful career as a tax and business lawyer in your own private practice for 14 years. During this period, you had 35 cases in the Georgia Supreme Court and about 6 cases in the Georgia Court of Appeals.
Judge Norton, thank you again for taking the time to speak with us today. I'm G. Kim, and I'm also a student in the St. John's Bankruptcy LLM student. You've obviously had the type of success that we're all looking to achieve in our own careers, and we're all wondering what prompted you to become a lawyer and what's been the driving force behind your success as a lawyer.
When I saw the hall this morning of the photographs or paintings of the former presidents, I noticed that Thomas Jefferson was about one of the first ones out there. And I recalled immediately that when I was in the 3rd grade, I read some kind of a biography or something of President John Thomas Jefferson, and whom President Kennedy one time, Jack Kennedy, described as the smartest man that ever entered the White House for any petition, any walk-in or being president. Anyway, I read this, and I decided then in the 3rd grade that I wanted to be a lawyer if at all possible. And I continued really all through the years having that ambition. High school, college, pre-law in college, and so forth. I went to a college called Emory University, and there about 90% of all the students were pre-med. I guess I was the only one in my whole class that knew he wanted to be a lawyer. And so that's what started me. Now, being a lawyer is another matter. I finally ended up in law school, and then in law school, like most of you probably, no, you all are different in that you all want bankruptcy. But see, most people go to law school, they don't really know what field of law, if any, they want to concentrate on or be, specialize on. And that was me too. I did not know when I was in law school what I wanted to be, but I became a law clerk to a United States District Judge in Atlanta. That sort of interesting. I picked up the paper one night in the Atlanta Journal and noticed that this Superior Court judge in Atlanta had been appointed United States bankruptcy judge by President Truman. And so in there, in the biographical or the information about him, they mentioned that he had married Carolyn Newton of Gainesville, Georgia. Well, that's where I live, and that's 45 miles from Gainesville. So that weekend, I went to see the daddy of the wife of Judge Hooper. And as a man I knew all my life, I'd walked by his house for years and years. It's now a historic district, that street. And I went to see him, and he was on the front porch. He and I were on the front porch on a Saturday morning, talking about this, and I told him about Judge Hooper being a federal judge, and I think they have law clerks. That's what I thought. I did not really know, but I knew the Superior Court judges in Atlanta didn't have any aides, didn't have anybody. So I told him about that, and I said, I'd like for you to write him a letter or call him and tell him my credentials and my history in Gainesville and recommend me. And so we were there on his front porch, and he said, well, I don't know whether I can do that, WL. People call me WL rather than Bill. Nowadays, people call me Bill. But he said, I don't know whether I can do that. You know, your granddaddy wasn't any good. Says he never amounted to anything. Actually, he did. And said, your daddy is not any good. He's not, he says he's a sort of a failure. That's strong too. And says, the only thing about you that I really can say good is your mother is a wonderful, wonderful woman. And about that time, there was a window there, and his wife was hearing this in the living room next door, and we heard this loud voice say, Charlie, shut up, quit that. And so anyway, he wrote the grandest letter you ever saw from me to Judge Hooper. And I went down to see Judge Hooper, and this was in the summer of 1949. And had been in law school 3 years and 2 quarters. And so, funny thing, back in those days, Dick, I don't think a lot of people applied to be law clerks. And there I'd been in the military 4 years and had been a second lieutenant, a first lieutenant, a captain. And there I was taking this menial task of, so some people would think that was sort of odd. But anyway, I wanted a job. And I knew that we had 7 or so, 5 or 6 or 7 classes of normal classes of law school that were now in law school, and they were graduating in about 2 or 3 years. And there was such an influx of lawyers, graduate students into the Atlanta and Georgia area, that nobody could get a job. And this was 49 and 50 and 48 along in there. Nobody could get jobs because there were too many lawyers being cranked out. There are probably too many lawyers being cranked out now, but now back then they certainly were. And so I thought this was an opportunity and took it, and he gave me a job. But I stayed with him about a year and a half. We had a lot of habeas corpus cases and other cases involving, there's a federal prison there. And I guess I wrote hundreds and hundreds and hundreds of memorandum and really opinions for him about that. But when I started thinking about what kind of law I wanted to go into, or what I thought, well, here I am 4 years behind. I've always thought that I was about 4 or 5 years behind everybody else in the practice of law of that year. And I guess that's one reason I worked harder than some people, and because I wanted to catch up. And so I looked around as to what kind of specialty that I wanted. I didn't want to be a general lawyer. I knew that was hard to learn multiple disciplines. And so I looked around. I looked at airline, CAB, FAA, who could I go learn that? But trouble with airline, that'd be Washington, D.C. or New York or someplace. Where would the business be? So I rejected that. And then I talked about UCC lawyer, and anyway, then I said, well, maybe tax lawyer. Because no matter where you go in the United States of America, tax is going to be a problem. That was what I figured anyway. And so I said, well, I want to be a tax lawyer. So then I started thinking about where to go, and I went to see some people who'd been in the Justice Department of Washington, some advisors, some of them former judges. The judge in Atlanta has, and that was true then, we only had 2 judges, and they have 11 or 12 now in the Atlanta Northern District. But the Savannah District and Brunswick and the Macon District and Columbus Middle District don't have near as much business. So sometimes those judges would come up to Atlanta and stay 2 weeks and handle cases for us. Incidentally, they still do that because Atlanta has so much business. And so I knew those judges. I'd gotten to know those judges. So anyway, some of them I asked, and one was a former district judge who's now practicing law. And I said, I want you to help me, if you can, get into the Internal Revenue Service and learn tax law. And he said, well, that'd be a foolish thing for you to do, to try to be a lawyer and go into the Internal Revenue Service. That you could get assigned to some department and you could learn to be the greatest national expert on uranium depletion or something. And so, when you get out and practice law, it wouldn't be any uranium depletion or something. So what you want to do is go to the Justice Department. And so he says, they got real lawyers up there practicing law and all of that. And so he had been, by the way, he had been in the Justice Department during World War II. He'd been a U.S. attorney in Atlanta and later district judge. And he then was, during World War II, he was in Washington, D.C. In the criminal division. And one of his roommates was former or later Clark, who was on the Supreme Court. They were big buddies. And so, what's his first name? Clark. So he said, well, you ought to go to the Justice Department. So then I tried to apply there, and finally I got in there, and luckily got in the appellate section and learned all kinds of things there. Everything I did up there was far above my head. I was incompetent, really, to be there, but I was there. And handling cases all over the country in the Second District, Second Circuit. One of the first cases I ever had was in the Second Circuit in the tax division. And what they did, you wrote a brief, and then somebody else in the tax division would write a brief, and there'd be 3 arguments that week in a court. and they'd assign you to like Foley Square, Second District, Second Circuit, and they'd give you 2 other cases too that you didn't write. So that meant you had to study and present that to that court that week. And the first case I ever had was Judge Learned Hand and Judge Augustus Hand. You all have heard of that, hadn't you?
Right.
And Judge Case, I think. And so I had cases like that up there in the Second Circuit. I stayed 3 or 4 years there, and then I had an opportunity or invitation by the Attorney General of Georgia to be head of the tax department, revenue department of the Attorney General's office in Georgia. And so I took that job. And then that meant I learned a little about federal tax law, and then I went to state and I learned a little about that. And then several years later, I went into practice of law and held myself out to be an expert in tax law. Now, that answers your question, I guess, or you got any other questions about that?
Good morning, Judge. My name is Carrie Hardman. I'm also an LLM student here at St. John's. You mentioned your expertise in tax law. How do you think that your tax background and all of your experiences in the tax field helped or hindered your bankruptcy practice?
After several years of practice of law in Atlanta and Gainesville, Georgia, I had offices in both towns, and I commuted to Atlanta, which is 45 miles away. That's where the real tax business was. I was a little wrong when I said that I thought tax law was all over the country. It really isn't. It's only in the big towns, big cities. And so I opened up office in Gainesville, Georgia, which is my hometown. It's not a tiny town, but nevertheless, I realized fairly quickly that, well, that is within 3 or 4 months, that really the oyster to be mined was in Atlanta as far as taxes is concerned. And so I opened up offices in Atlanta and with another fellow that was a tax lawyer. And so I was a tax lawyer for a number of years. And just out of the blue one time, two district judges walked in my office on a Saturday morning and told me that they wanted to talk to me about becoming a referee in bankruptcy. And I said, what in the world do I want to be that for? And which, that's the truth. I didn't care anything about that. And so I'd been law clerk, and we'd had a couple of bankruptcy cases, and I knew the referees in Rome, Georgia, and I knew them in Atlanta. And so they told me that they had decided not to reappoint the fellow that had been referee for the last 6 years. And apparently they thought that the Senator Russell had recommended him. It turned out Senator Russell just wrote a letter saying, this is a nice fellow, I hope y'all give him consideration. And incidentally, that's the way a lot of appointments get made. Some senator writes a letter that he doesn't mean to really this fellow get the job, he just courtesy. Anyway, they held him for 6 years and he was a total failure. So they said that they weren't going to reappoint him, and they didn't want to announce that they were going to reappoint him until they had decided who they were going to appoint to the job. Now that would be completely horrific and against the law, the way they do things nowadays. Nowadays they send out applications or announcements of an opening, and they hear applications, and then they go through all kinds of interviews and this and that and the other as to whether they're going to appoint somebody a bankruptcy judge. And so, but back then, they said they wanted to appoint me. And I said, well, I don't know anything about bankruptcy. And they said, well, bankruptcy really is business law. And you've been when you're a tax lawyer, really you're a business lawyer. You're in your cases that you had as an individual is really business, and so bankruptcy really is business and litigation. And you've had lots of litigation, and so we besides, they're talking about nowadays, I don't know where they got this, but they said that there's been talk in Congress to create a new court called the United States Commercial Court, and that they were going to put into this court bankruptcy and all the commercial business that the district court has. And it sounds like a good idea, I guess, then and now. Anyway, they did not do it. And they said, come aboard, because in just a few years, they're talking about making this a bankruptcy court or a commercial court, an Article III court, and you'll have a leg up, and you'll be an Article III judge. And because I'd mentioned that I didn't want to be considered every 6 years for reappointment to some job that I really didn't care for, the referee. So finally, after a couple of months, I decided to take it. And so I was appointed bankruptcy judge. And then when I started hearing cases in bankruptcy court, I would be hearing the lawyers talk about some kind of issue. And I said, I don't know what in the world these two guys are talking about. And then all of a sudden, this would invariably happen. All of a sudden, one of them would say something, and I would really say, well, this really isn't a bankruptcy thing. This is something else. This is just like thin corporations in tax law, or this is just like something, a principle that involved in tax law. So really, my tax law experience, and by the way, I had been a securities lawyer too. I had been asked to revise or modernize the securities laws of Georgia that hadn't been revised since 1936, and I had done that. And so from then on, I had a lot of intrastate and interstate small corporations to be public companies. And so I had a lot of that practice along with the tax. And I would just, like a light bulb going on, all of a sudden I'd realize, well, this is a simple little case. It's just like what I've had before. So I think it helped me very much. And I think those district judges were correct that really bankruptcy judging and bankruptcy law, that is a broad spectrum of law practice. You have everything involved in corporate and business and other fields of law that are involved in bankruptcy. And so, anyway, my practice helped me very much.
You've talked about how your tax background helped. How did your work arguing before appellate courts affect your time on the bench?
That's a good question, but I guess appearing before all that many courts, and really being a law clerk, which is what I recommend that any of you all could ever get to be a law clerk to a federal judge, especially a trial court, that you ought to do it, because it's a great experience, because it throws you into lots of observations of other cases. And the appellate court that I had threw me into before lots of judges, and they ask a lot of questions from the bench, and you learn to be better on your feet, standing before people and answer sometimes inane questions, but somehow or another feel it. I suppose that experience before judges in courts would, when you think about the tax issues in the appellate court, that case really isn't just about tax, it's about that business and what they did and so forth. And so you're learning a lot about business, I think. in addition to being the statutory tax provision. So I think the appellate court, also, I think it insulates you from being awed by people or judges. And as you all will see if you've been to the Supreme Court and observed lawyers arguing before the Supreme Court, you see that some of them come there with a precondition of so much awe that actually they're scared to death. And when somebody asks a question that you're presenting something else and they ask a question really off the wall or something, or that maybe really applies to that judge's thinking in that case, that it really, you can see almost the terror of some of the lawyers before the court. And I think that arguing before lots of courts around the country eliminates some of that awe or whatever you call it.
Right.
Judge, you've influenced and mentored so many people throughout the years. We were wondering, did you yourself have a mentor? And if so, how did he or she influence you during your career?
I suppose it made me start thinking about who along the years have helped me or maybe advised me or something. I think that everybody ought to seek mentors and ought to really ask advices of people. I didn't ask advice of people far enough that I was sort of an independent character, and I didn't really want to ask anybody else things. But I think looking back on it, I would have counseled with people far more than I did. But I did have one professor at Emory that I thought very much of, and he later advised me about some things. The judge I worked for, Judge Frank Hooper, was a law clerk to Senator George, who's Georgia's famous senator, only when Judge was on the Court of Appeals, and he served as a Superior Court judge in Atlanta and then was a U.S. District Judge. And he was sworn in the very day I became a law clerk. So he used to say that we learned being a judge together. And all through the years, he was trying to advise me about things and trying to get me to apply to the district court or something like that, which I never did. But he was a mentor of sorts. And he wanted to write some books on habeas corpus and on marital law. And he had files, voluminous files on that, but he never wrote the book. You know, thinking about writing books is different than actually getting around to writing books. And he never got around to writing books, but he always had that ambition. But anyway, he advised me about a lot of things. Down the hall from him, though, there was another judge, Judge Robert Russell, who had been district court judge, and there was later on the Court of Appeals, and he was down the hall from us and when I was in the federal courthouse. And I became great friends of him. He went to lunch with us a lot. And he was the brother of Senator Richard Russell, who was in the Senate for 30 or 40 years and was a great senator. And that brings up something. Nowadays, I doubt if anybody, any senator would ever recommend his brother to be some district judge, or if he did, that whether he would get appointed. But he did, and incidentally, he was a great fellow and a great judge. And his father had been a Supreme Court judge. So he was sort of a mentor for me. One time when I applied to be in the tax division of the Justice Department, I went down to see him and asked him if he would recommend me. We would write the two senators. The two senators recommend you to be these things in the Attorney General's office. They don't take people right off the street. They they have people recommend them, and so I knew that. So I got all these judges that had met in my court and got them to write to tax division. And then I went down to see this Judge Barbara Russell and asked him, would you write? He said, no, Bill, I have never, since I've been on this bench, and he'd been there 10 or 15 years, I've never written my brother, Senator Russell, a letter recommending anybody. I've always thought that that was improper. And I've turned down a lot of people, and so I can't do it. And so I said, well, that's fine. So about 2 weeks later, his secretary comes down to the office to me and says, Judge Russell wants to see you. And so I went down to see Judge Russell, and he said, you remember a couple of weeks ago I said I couldn't write you a letter? And I've never written a letter for anybody to Senator George or Senator Russell. But I've just written a letter to Senator George and Senator Russell recommending. I decided to change my mind this once. And so I don't know how. But I know a lot of things I was a mentor for. But so we were, good friends, and that's the way you do. Other judges that I have had over the years was Chief Justice William Duckworth. I had a lot of cases in the Supreme Court of Georgia, and the judges got to know me, and he became partial to me, and we would have lunch in the cafeteria of the courthouse, and sometimes they'd join me or I'd join them. So I guess he would be a mentor. But I've got other mentors, I guess. I don't know whether they call them mentors, but people that I appreciate. They're looking back on it that did something for me.
Judge, your treatise, Norton, Bankruptcy Law and Practice, has become one of the leading references in the field. It's grown into many volumes, thousands of pages. Can you share with us the story of how you first sat down to compile and edit this?
One day I had a phone call from the editor, in-house editor, they called him, managing editor of Callahan and Company, which is a publisher about 120 years old in Chicago. And this was after the Bankruptcy Reform Act of 1978 was enacted. That was enacted in November of 1978. And I got a call from them about that month. Said they wanted to come down and talk to me. So they came down to Atlanta, and I was on the bench. And they said they wanted me to author a treatise on bankruptcy law. And the new bankruptcy law, completely revising the 1898 Act. The 1898 Bankruptcy Act had been enacted and was now 70 years later was still the law. And Congress had spent about 10 or 12 years thinking about it and then finally getting around to enacting it, and they did. They said, we think that it's right for us to come out with a new bankruptcy publication to compete with Collier on bankruptcy. And the Collier on bankruptcy had been around since Professor Collier first started a volume in 1898, right after the act was enacted. He said, we think that we can, now they're going to have to start over, and we'll, from scratch on this new act, and they've got to come out with a new edition, and we can maybe compete with them. Says they did that to us several years ago. Callahan and Company publishes, or did then, now my publisher, current publisher, publishes Merton's on taxation. And some of you know about Merton's. It's a famous publication, 30 or 40 volumes on taxation. They said that was the Bible, and that was commanded the market until the Internal Revenue Act of 19 and whatever it was says, and then Matthew Bender came out. They got some professor to write, Rabkin and Johnson, I think it was. And so they started competing with us because of this new act. And so we think that we're going to turn around and compete with Collier on we'd like for you to write 5 or 6 volumes and about 2,500 pages. And so I said, well, why'd you come to me? Well, you know, Pinegate was one thing. I don't know what about Pinegate really influenced people, but anyway, that made me some notoriety around the country. And so they said, but you wrote a book on chapter 12 that Harrison Company did. I think I sent you all a copy of that, and some of you are familiar with that. And that's right. After Pinegate, Emory University asked me to write a law review article on chapter 12. And so I did. I started writing it. And then while I was writing it, I hadn't thought about publishing a book, but I'd written this article. But then I learned that the Emory staff, folks like you, had engaged the losing attorney in the Pinegate case, and that he was writing an article. Those two guys were writing an article in the same issue. And I said, well, that doesn't give me a lot of comfort. I'm going to write a law review article about the Pinegate case, and you all are going to publish an article by the losing attorney. It looked like it might appear to some people that'd be a debate, and I don't want to be involved in any kind of debate about this opinion. The opinion stands for itself, and that's it. And so they wouldn't withdraw the article by this attorney or 2 attorneys that were in the losing side of the Pinegate case. So I said, okay, I withdraw mine, and I did. Harrison Company, a publisher in Atlanta that publishes books in the Southeast, and they were about 150 years old company too, very highly regarded in the South. And so they contacted me and asked me to write this book, and that book ended up being it. That book started out as an article and ended up being a book. And one summer I had 4 law interns, I called them, working for me. They were students in law school, and they would come and work 2 or 3 months while they were people that couldn't get jobs in law schools or something, and working for me was better than working at McDonald's and other jobs that they might get. So I invited the school, Emory, and the University of Georgia, to students to come and apply, no pay, and they'd come, and they have to come at 8 o'clock in the morning, and they have to stay till 5, and I'd let them off, and I'd have lunch with them 1 day a week, and so that worked good, and so 2 of those helped me edit and write that book that summer. So that's how I started writing that book. Now, then though, they wanted me to write, this was Callahan, back to Callahan and Company. They wanted me to write it singly. And I said, I had mentioned, well, it would take me some time to try to get the people to help me write this book, contributing editors. They said, no, that's not the way we want to do it. We want you to write it. And I said, well, I'm in a busy bankruptcy court. It's not like the Southern District of New York, but nevertheless, it's busy as the dickens. And I had several thousand cases to file a year. I couldn't take time off to do that. I wouldn't have time to do it myself. I wouldn't mind doing it with contributing editors. No, we don't think you ought to do that. I said, well, in the first place, Collier already has lists of people on the spine of their books, of people that contributing editors of Collier. And to me, that sets the pattern. I don't think anybody coming out with a book with nobody but one person as the author would compete with all of those people that that are on the spine of Collier. And they've been in business now for 70 years practically. And people think that those people write that treatise. As in reality, I think a lot of them maybe 10 years ago wrote, but they're still on the spine. But I felt that it wouldn't sell. And I said, Sue, I'm not going to take this role unless you let me have contributed. They said, well, we've never had an author succeed in supervising and getting production out of associates that help him or her write the book. So it ends up that the time schedule of the author may be good, but these contributing editors, timely submission of their manuscript doesn't work out. We've never had anybody succeed. I said, well, I can't help you then. You got to have contributing editors. And I don't even know who I'll get. And so finally they agreed, and then I signed a contract in January of 1979, and the code actually took effect that following December in '79, and so I signed that contract and then started writing. I then started recruiting people to help me write that book. That's not easy either. You're finding really people that you want, you know, if you're going to do something like that, you want people 3 times as smart as you are to help you write the book. And that's what I was looking for, people a whole lot smarter than me and more experienced. And so I started looking around, and I called, one of the first people I called was Professor Kennedy, Frank Kennedy from the University of Michigan, and who's one of the gurus of Dick Lieb. Dick Lieb thinks a great deal of, and anybody in bankruptcy practice thinks a great deal of Vern Countryman and Frank Kennedy. They're the 2 professors of top rank in that era of the law. We're now creating some other top rank legends in professorship, but so I called Frank Kennedy and I said, I know you can't help me. I know you're too august and too beyond helping anybody else write a book. You ought to write it yourself. But you could recommend some people. And he says, well, I'll tell you what, when you put this phone down and before dark, you call Gerald Smith in Phoenix, Arizona, because he was my deputy director of the Commission on Bankruptcy Laws of the United States in 1969 through 1973. And so I did, and I guess he became one of the first. Then I got a fellow in Alabama named Chandler Watson, who was considered and he was on the faculty of the Judicial Center, because I knew those people, and they were all smart, very capable people. So I called him. Then I called a fellow named Howard Schwartzberg, who was a judge up in White Plains, and he's a good friend of Dick Lieb's. In fact, he was on the staff of Dick Lieb when Dick Lieb was editor of the Law Review at NYU. You know who was also on that staff? King. Harry King. So if King turned out to be, a legend in the field of bankruptcy, I think that in law school he was only a article editor or a reviewer or something on the staff of Dick Lieb. So where did that make Dick Lieb? And so I finally got people to help me, and we started deciding what to do. We had a meeting down in, I was on the faculty at that time of the Federal Judicial Center, and we had 5 regional lectures around the country. And we met down at, they were meeting right after that in the spring, like in March of '79. And I invited all these contributing editors to be down at that meeting of the Don Cesar Hotel at St. Petersburg, Florida. It was a seminar by Judge Pasquet. Well, I got Pasquet too to help me, and so be a writer. So we met down there, and similar to this, we had all the contributing editors, about 13, and not near enough. I kept about 30% of it to write myself, which was too much and almost killed me before I finished that 5 or 6 volumes. And so we decided at that point, how are we going to do this, this book? How is this book going to be? How are we going to distinguish ourselves from Collier? Collier has a, I think they do it now, I don't know. I hadn't looked at Collier since I started writing this book. Because I don't want to be, influenced by what they do to might be in my subconscious mind as being something that I want to copy, and I didn't want to do that. But there was competition to Collier back in those days called Remington. And Remington wrote, their book was organized a little different from Collier. Collier was, you follow the code section. Every code section is a chapter or whatever, and that's the way you move through. But Remington was subject matter, and it had subject matter, filing of the case and something like that, filing of the plan anyway. And we thought that was a better way to treat it, because really the code sections of the bankruptcy code, you look at one code section, and during that code section, it will say, refer you to another code section. And the first thing you know, you got 5 books on your desk of that code section, plus these others that refer you to something else. And so we decided, well, let's try to put, when we have this code section, let's try to cover those references also in this. So that's the way we attempted to do it. So that's the way we started the organization of the preparation of the treatise. Have I filibustered enough on that question?
That's great, thanks, Judge.
Judge Norton, I have a question. Judge Norton, thank you again for taking the time to speak with us today. As the former chairman of the Rules Committee for the National Conference of Bankruptcy Judges, were there rules that you saw enacted that hindered bankruptcy practice, or conversely rules that helped bankruptcy practice, or you would have liked to have seen enacted?
I was appointed to that job. Maybe I had that job before the Rules Committee was established. But I canvassed all of the judges in the National Conference of Bankruptcy Judges, or actually all the judges in the nation, to let me know how they felt about these rules. Those were the first rules going to be promulgated under the new code, I think, and I wanted their input. And so I did get input from quite a few. And despite what a lot of people think, I thought at that time, that is before the appointment under the bankruptcy code, there are a lot of smart referees in bankruptcy or bankruptcy judges around the country. And there's some that not as smart as others, but there are some capable and good judges around the country. As good as any you'll find on other courts, to tell you the truth. But I've canvassed all these people, and they would write me back, we ought to do something about such and such. And I said, well, write me a rule. Don't make me do it, write me a rule. And so they would send me things. Then I would take what they wrote and send it around to some other people and say, you got any other additions to this type of a rule? And so I put all that together and was invited to appear before the advisory committee on the bankruptcy rules at a meeting in Chicago. And that rules committee, there's about 12 people on it, and the chair at that time was a fellow named Aldesert, Aldersert, he's a judge on the Third Circuit. And so I went before that committee and gave them my opinion about these rules. I was going along pretty fast, reading them, and I'd been about 10 minutes, and finally Judge Aldesert interrupted me and said, "Judge Norton, you're going too fast." Of course, us Southerners don't go fast from normally, see. So he says, "You're going too fast. I wish you would tell me, I wish you'd go slower, because we consider you the most important witness before this committee. And we're going to have lunch in a minute. We should join this lunch. And this afternoon we'll come back and we're going to thoroughly do that." So they thoroughly listened to me. But I think in answering to your question about would be some kind of change, it would be that at that time I thought there ought to be separate rules for Chapter 13 as well as rules all over. A lot of these rules, I thought at that time, that the rules that were promulgated or they were considering were too much attuned to and consistent with Chapter 11, and really didn't consider some of the things that arose in Chapter 13. I made that recommendation. I don't think they did it. We don't have separate rules now, do we? Do we? Well, do we have Chapter 13 rules as well as Chapter 11 rules? Huh?
I think so.
Okay. Well, anyway, that they didn't at that time, so maybe our recommendation was carried through.
Got through. Anyway,
Huh?
we're going to get to an interesting,
Yeah.
another interesting.
So that's the
topic.
only thing that I at that time thought was paramount.
Thank you. This next question, Judge, actually deals with your Pinegate opinion. After the Pinegate decision was rendered, did you happen to see an influx in bankruptcy filings in your court, or perhaps hear of others in other courts around the country, by real estate developers whose sole purpose was just to write down non-recourse debt, only then to turn around and reap the benefits of that when the market swings back in their favor?
Well, I think that's probably a good question too, but I really don't know the answer to that. I know we had an influx of a lot of Chapter 11 cases. In the first place, I don't think they were developers. I think that they were owners of property that had developed, and they were trying to get revenues, or tenants if it was apartments, or tenants if it was an office park, but they ran into trouble getting tenants enough revenue, and then they'd have to file Chapter 11. At that time in the United States, there was, as you all know, the Chapter 11 is confined to, one, a single property, and two, it's confined to unincorporated entities. And that gets back to the creation of Chapter 12 after 1938. It was sort of an afterthought of the Chandler Act. And the influx of cases after Pinegate probably occurred throughout the United States. Atlanta had about 600 cases from 1938, when Chapter 12 came into effect, until about, that was 600 cases in the United States. There was one in Atlanta from 1938 until 1973, one, an office building. And then in 1973, I think, or 4, we started getting some Chapter 12 cases throughout the United States. One reason was that the Congress had passed very favorable tax advantage laws under the limited partnerships. And so limited partnerships throughout the United States were forming groups and to build apartments or something like that. And so that's what started it. But the other thing that started it, and the influx, was the oil embargo of 1973 and 4. That fuel rates, when I was commuting to Atlanta, there was gasoline was 25 cents a gallon. But all of a sudden in a year, it became $1.25. And gas, natural gas in apartments, most of the apartments back in those days had apartments with utilities included. And all of a sudden, the apartment developer would realize that the fuel costs were more than the mortgage, and that so they'd file a Chapter 12.